been relegated to traffic court in some of these unknown counties in the state of Florida. It took me, no lie, 60 seconds, and my case was dismissed when she finally called me. And I'm sitting there going, she didn't even ask. Anybody got any place else to be or anything? She took all of the officers that worked midnight shift last night. Their cases went first. It took an hour and 26 minutes. Not that I remember it very well. Not that it bothered me.
6 minutes. Good afternoon, sir.
Judge, we put this just as a case management conference because we had a deposition scheduled for 2 days ago. Turns out that the witness that we were trying to serve, they couldn't find her. The state's going to send their investigators out to see if they can round them up. We had already set it for pretrial, which was for September 11th. And at this point, I've talked to Mr. Miles, and our position is that we want to try this case next month because we don't think they're going to find that witness. Okay. And he's been in jail for quite some time.
So, Mr. Miles, I'll see you back here no later than September 11th. We'll be looking at going to trial at the end of September. Okay. So yes, I'll see you no later than September 11th.
Yes, sir.
Thank you, sir.
Thank you.
Mr. Noakes, what else do you have?
Judge, I've got Mr. Douglas Stentz. He's actually at 2:30, but I don't know if he's an inmate, if he's here.
I'm not sure he's up here yet.
Okay.
He's not up here. He's down.
That's fine, Judge.
Mr. Noakes, if you'll approach.
Yes, sir.
Not about any pending case.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online.
Okay. Any other private counsel? I don't see. Ryan Langley? I don't see Mr. Langley. Jenna Linton? That's Mr. Klein's case. Okay, let me see. Pro se's William Locke.
He's an inmate, Judge.
Okay, got it. Thank you. Brent Mallett. Let's go with that. Alan Maltius Carrillo. Eric McNamara. Hello, Mr. McNamara. 23 CF 1499. Does the state have an offer for Mr. McNamara?
Yes, Your Honor. Let me just pull it up real quick.
Good afternoon, Mr. McNamara.
Yes, sir. How are you doing today?
Good, I'm glad you're here.
Yes, sir.
Sorry, Judge. Just scrolling through our... Your Honor, at this time, the state would offer Mr. McNamara to plea as charged and adjudication of guilt, standard probation for 2 years, $615 in court costs, substance abuse evaluation within 30 days, and to begin any recommended treatment within 60 days with random urinalysis. community service work of 24 hours.
Mr. McNamara, the reason why it has to state that is you have the right to an attorney, you have the right to a trial by jury. Have you ever been adjudicated guilty of a felony before?
Yes, sir.
Have you ever been on probation before?
Yes, sir.
So you know what you'd be getting into if you accept the state's offer. You'd be on probation for 2 years. You'd have the court cost, community service, 24 hours, substance abuse evaluation, random ear analysis.
Yes,
You have
sir.
the right to accept that, and you'd be waiving your right to an attorney in a trial, or you have the right for me to appoint an attorney if you qualify financially.
I was going to see if I could get a continuance. I'm trying to get an attorney as we speak, a little more time maybe.
Okay? Madam Clerk, you've got information?
Yes,
Okay.
I handed it
So, Mr. McNamara, you're charged with possession of a drug without prescription and also possession of paraphernalia. That's the information that you were given. So I'll set your case. Is the date on there, is it November 13th?
to me.
September 11th. I'll see you back here September 11th at 9 o'clock. If you hire a private attorney and they file a denial for you, then you don't have to be here on the 11th, but stay in touch with that private attorney.
Yes, sir.
Okay?
Thank you.
Thank you, sir. Jessica Musselwhite,
Muscle wipe?
Musselwhite, 23 CF 1551. Does the state have an offer for Ms. Musselwhite?
Yes, Your Honor, I'm pulling that up real quick.
How are you doing?
I'm doing all right, thank you. You?
Yes, ma'am, well, thank you.
Your Honor, that would be to plea as charged, adjudication of guilt, 3 years of probation. The court would reserve 90 days in jurisdiction to reserve the amount of or to determine the amount of restitution, $615 in court costs, 48 hours of community service work, no contact with the victim, and an anger management course.
Ms. Musselwhite, have you ever been convicted of a felony before?
I have.
Have you ever been on probation before?
No, sir.
Okay. Do you want me to appoint a public defender if you qualify financially?
I think I would like to seek my own private attorney.
Okay. Is there an information for Ms. Musselwhite? So, Ms. Musselwhite, you're charged with criminal mischief. That's why you're here. They'll give you a copy of the information. You'll need to be back here on September 11th at 9 o'clock. If you decide to hire a private attorney, do it sooner than later so that they can start working on your case. If you decide you want a public defender to represent you, you can fill out a financial affidavit at the clerk's. Get you that paperwork.
Yeah.
You can ask to hear it again.
May I ask to hear the state's offer again,
Sure,
please?
yes, ma'am. And I'll tell you what it is. It's an adjudication of guilt, 3 years probation. The court would award restitution, but reserve jurisdiction for 90 days to determine the amount of restitution. That's damages to the alleged victim. You'd have to pay the court cost, perform 48 hours of community service work, enter and successfully complete an anger management course, and have no contact with the alleged victim.
Thank you, Your Honor.
Good question. See you here September 11th at 9.
Have a good day.
Thank you, ma'am. You too. Nicholas Meyer, M-Y-H-R-E. I don't see Mr. Meyer. Kendra Perkins? Kendra Perkins, no. Ronald Phillips? Ronald Phillips. Julio Ramos Perez?
That's an inmate.
Oh, okay. Thank you. Patricia Roberts.
Judge, we handled that this morning. I think there was also
Kyle Shields.
appearing by Zoom. Ms. Ursula.
Thank you. Thank you, ma'am. Hello, Mr. Shields. Mr. Shields, you're charged with possession of drug paraphernalia, or I'm sorry, with methamphetamine with intent to sell. Do you wish for me to appoint the public defender if you qualify financially?
I'll let hire one of my own.
Okay? And I'll see you back here on September 11th at 9 o'clock. You do have a copy of the information.
Yes, sir.
Thank you, sir.
Thank you.
Mr. Ursulo is coming on Zoom. It's case number 23 CF 1569. Mr. Ursulo, good afternoon. Can you hear me? Mr. Ursulo? Hello? Oh, nope. Okay, hold on one second.
Sorry, I was updating.
Hold on one second. Mr. Ursulo, can you hear me now?
Yes, now I can hear you.
Good, thank you, ma'am. Yes, ma'am, you're charged with drug possession and possession of a controlled substance without a prescription, possession of paraphernalia, and petty theft. Does the state have an offer for Ms. Ursulo?
Judge, the state's offer is going to be an adjudication of guilt, 24 months probation, the cost will reserve jurisdiction for restitution, 24 hours of community service, no trespass at Alvin's Island, and a shoplifter's awareness course.
Okay. Mr. Ursulo, do you wish for me to appoint a public defender if you qualify financially?
Yes, Your Honor.
Okay, how much money do you make per month?
I'm currently unemployed, but just recovering from an accident.
I'm sorry, you're recovering what?
From a car accident last year, so I'm
Okay.
currently unemployed.
Okay. How long have you been unemployed?
Since March last year.
Okay. I do appoint the public defender to represent you. Mr. McKinney's coming to the lectern.
Ma'am, do you have a pen or something to write with?
I don't, sir. I can get one.
Okay. My name is Jason McKinney with the Office of the Public Defender. My assistant's phone number, the office phone number is 850-651.
Wait, hold on, geez.
It's okay if you want to grab a pen.
Pen.
Yes, ma'am.
Sorry, let's see. apologize. You never find a pen when you need one.
Yes, ma'am.
That's okay.
My assistant, my mother's forever. Thank you. Just kidding. Thank you.
Okay. My phone number is 850-651-7350. My name is Jason McKinney. So let me get a file open today, but go ahead and schedule an appointment to talk to me over the phone, and we can discuss your case.
Thank you.
We would enter a plea of not guilty for today, waive formal reading of the information. And Madam Clerk, is the next court date scheduled September 11th?
Yes.
At 9 a.m.
Mr. Sulo, so you'll need to talk to Mr. McKinney about the case. Unless he tells you otherwise, you'll need to be here September 11th at 9 o'clock, okay?
By Zoom again?
Yes, ma'am, you can do that.
But
Okay.
certainly talk to me.
Southern California.
Talk to me prior to that date, and we can talk about all of that.
Okay, thank you so much.
Thank you, ma'am.
Thank you. Have a good day.
You too. Ms. Davis, thanks for reminding me of that.
Yes, sir.
Next is Angelica Walker. Nope. Okay, then I've just got, other than the ones that I passed that weren't here originally, to the PD.
First, I have Jenna Lorenzen, Carol Litz, Kayla Lavecchi, Mary Mason.
Wait, we can hand you over to Reggie.
Okay. Your Honor, this is Ms. Mason. We do have a two-count information. We're going to waive the formal reading, enter a not guilty plea. Ask that this remain on the 9/11 docket.
Okay. Ms. Mason, I'll see you on September 11th at 9 o'clock. Stay in touch with Mr. Kleins, okay?
Thank you so much.
Thank you, ma'am.
Your Honor, if we could recall Ms. Lavecchi.
Ms. Lavecchi?
I talked to Mr. Gomez. I think the state's going to have an announcement.
Your Honor, at this time, we're going to be announcing a no pros. Information has been filed. We're going to be announcing a no pros of that case.
Okay. 23 CF 1548, Ms. Lavecchi's case is dismissed.
Next, I have Jimmy McDonald. Your Honor, there's a Charles McGough on the docket. This is the individual on Monday that the court granted the bond. Yesterday, as of 3:48, there was no information. I saw it today. I filed a waiver yesterday. I didn't get a chance to file the not guilty plea. I'll file that today, but if the court would allow me to enter a not guilty plea to the information, it's a one-count information, and Mr. McGaugh's case has already been continued to.
Is there only one count? There's two on the docket.
I believe there's just a one-count information.
I believe that we only filed an information on one count. Let me double check, Your Honor, and I will, what's the,
It's
23 CF 1555.
Yes.
just a one count, though,
Yes.
right? Yeah.
Yeah, I saw it at lunch and got distracted with my food, so.
Yes, sir. So the denial, yes, sir. That's-
And I believe that the court continued this on Monday to November. Is that,
I can look to see the minutes. She didn't notate on there.
I would ask the court for a one-cycle continuance. We are going to have to take depositions in this case.
Okay. Yes, sir. It's continued till November 13th.
Thank you, Your Honor. Stephen Mosley, followed by Keita Nicholson. This is Mr. Mosley. He is present and approaching, Your Honor. We do have a one-count information. We will waive the formal reading, enter a not guilty plea. I did talk with Mr. Mosley. We are going to be taking a deposition in this case. Because of that, I would ask the court to continue this one cycle. There's just no way to get that done before 9/11.
Mr. Mosley, I'll see you back here on November 13th at 9 o'clock. Thank you.
Your Honor, Ms. Nicholson, I believe, there she is. Rita Nicholson. And she'll be followed by Valerie Morris.
Hello, Ms. Nicholson, come on down.
Your Honor, this is Ms. Nicholson and 23 CF 1282. There is no information that has been filed yet. I talked with Ms. Barrickman with the State Attorney's Office. I would ask the court to put this on the, is 9/14, is that an arraignment date?
Yes, sir.
I would ask the court to put this on the 9/14 date for arraignment.
Okay. So, Ms. Nicholson, I'll see you back here on September 14th at 1:30, okay? Thank you.
Last I have this afternoon, Your Honor, is Valerie Norris.
Hello, Ms. Norris. Good afternoon.
This is Ms. Norris, Your Honor. We do have a 4-count information. We will waive the formal reading, enter a not guilty plea, and just ask that Ms. Norris remain on the 9/11 docket.
Okay. Ms. Norris, I'll see you on September 11th at 9 o'clock, okay? Thank you, ma'am. Mr. Hines, did you say that's all you had for the whole afternoon?
Well, no. I don't have anything on the 2:30 docket. I have a number of people who aren't here yet, so that's all I have in
Yes,
the court.
Thank you. Yes, sir.
Good afternoon, Judge.
Good afternoon, sir.
Thomas Scott for the record. My first case, Judge, last name Paddock, first name Chantel, who is present and approaching, Your Honor. Correction. Ms. Paddock?
Nope. Okay, fake out.
I apologize, Judge.
Nope, not a bit.
If
Okay.
can we just pass that one up for a moment, Judge?
We're going to pass everybody who's not here, finish up who is here, and then we'll see what we do about the folks that didn't appear.
Thanks, Judge. Next case, Angela Pelopita. Next case, Judge, last name Raidma, first name Johannes.
Enter a written not guilty plea for the
Correct. I'll move past that one. Keep that set for 9/11. Next case, Judge, this should also be waiver on file for Maria, last name Rivera Meja. I did file a waiver, Judge.
Okay, but if she's here, why don't we bring her out?
Yes, Judge.
Good.
J. Baker, number 56, Nikki.
No, Mr. Rivera. Ms. Mejia, your attorney filed a denial for you, and so I'll see you back here on September 11th. You understand what the charges are against you?
Yes. I have,
Yes, sir. Sir.
I have here,
Yes.
I sent a mail, they don't give me my medication because I'm bipolar, and they don't give me my medication, they don't let me take a shower, they don't give me nothing, so only give me insulin. So the doctor signed me everything, something like that, because it's in hearing, this is no sick up or something like that. So I sent a mail to this, to Alison, from my family, from Mr. Moore. So she told me how she would help you, she must be okay. So what is it?
This is the story. This is the
Okay, thank you.
So I'll see you back here no later than September 11th But if your attorney sets a hearing before that date, or if the state offers you something you want to accept, then I'll see you then, okay?
So Wednesday, maybe,
Did you understand the judge?
Wednesday.
Our next court date's 9/11.
Mm-hmm. Okay, thank you.
Thank you, ma'am.
Thank you, Judge.
Thank you.
Judge, my next case I have, he is in custody. Last name is Sasser Williamson, first name Sean.
For those of you that weren't here earlier when I called your name, we'll loop back around and I'll get you, okay?
Sean Sasser Williams.
Thank you. So, Mr. Professor Williams.
Yes, Judge, this would be, enter a not guilty, waive formal readings, Judge, if we can keep this set, that 9/11 pretrial conference.
Mr. Sasser Williamson, I'll see you back here no later than September 11th. Okay?
All right.
Thank you, sir.
See you soon.
Next we have Aaron Lewis.
Judges, we have entered not guilty, waive formal readings, and if we can keep this set for that 9/11 pretrial date, Judge.
Mr. Smith, I'll see you no later than September 11th.
Yes, sir.
Thank you, sir.
And then, Judge, the next case I have is Sariana Smith. This is it. Who's present or approaching, Judge?
Thank you. Hello, Ms. Smith.
And Judge, this is we'll enter not guilty, waive formal readings. This was a case we ROR'd. And she had the baby, and she came today, and she wanted to be here. So I'm going to give her my card, and we're going to discuss the case and be ready for that 9/11 date.
Okay. I'll see you back here no later than September 11th. If the state offers you something that you want to accept before September 11th, your attorney can set it for a hearing. We'll have probably 200 or 300 people here that day. So if you want to avoid those folks, you can enter a plea before that, if they offer you something that you want to accept. Okay? Okay.
Yep. Judge, next case, last name Snow, first name Donna, who is present and approaching.
Hello, Ms. Snow.
And in this case, Judge, I checked this morning, I did not see any information filed.
Judge, this is a fugitive from justice case. So I'm trying to check and see, I know that there was the hold, I'm not sure what happened with the hold, so I'm trying to follow up on it. I anticipate filing a no cross in the case, or no cross actually, is the plan, but I just need to make sure that whatever the issue was that she had the hold for, that it's been handled, that it's not going to come back up for her, is really the issue.
Okay. So we want to continue this? Or?
Yes, Judge.
And Judge, if I may?
Sure.
Those, that outstanding charge right now is being addressed in Alabama's version of drug court, so there is no current hold anymore. Just want to say that for the record.
Okay, so you want to set it for September in hopes that it'll fall off before that?
Yes, Judge, so, because I've got to have the paperwork to make sure that it's done.
Okay, let's set it for September 21st at 1:30.
Is that an arraignment day, Judge?
It is.
September 21st?
Yes, sir.
Thank you.
So, Ms. Snow, hopefully he'll get it cleared up and you don't have to come back before me, okay?
Thank
And
you.
good luck to you in drug court.
Thank you, sir.
Yes, ma'am.
And then, last case, Judge, I might have been, I think I filed a waiver yesterday on this. Dylan Sloan, was that already put to 9/11?
Yeah.
Okay. Other than the two failures of behavior, that's all I had.
Okay?
Yeah.
Thank you, sir. Mr. McKee?
Judge, may I call two cases in order? Nora is present. We would acknowledge the receipt of a one-count information, waive its formal reading, and or plea of not guilty. And we'd ask for this to remain scheduled, I believe, Madam Clerk, on the 9/11 pretrial at 9 a.m.
Mr. Nora, I'll see you back here no later than September 11th at 9.
All right, thank you.
Thank you, ma'am.
Mr. Moore, please. Okay. Paperwork.
Leo Tinsley. Followed by Jillian Watson. Judge, Mr. Tinsley is approaching in 23 CF 1393. We will acknowledge the receipt of a one-count information and or plea of not guilty, waive its formal reading.
Thank you, ma'am.
Would ask for this to remain on the 9/11 court date for pretrial.
Okay. Mr. Tinsley, I'll see you September 11th at 9.
No problem, sir.
Thank you, sir.
Thank you.
Is there Jillian Watson in the courtroom in 22 CF 1880? Judge, I've called for Ms. Watson, and I have not gotten a response in the courtroom here today.
Okay. 22 CF 1880. What is the state seat?
KP's, Judge.
KPS will be issued for Ms. Watson. That means they'll arrest Ms. Watson, bring her before the court, and the first appearance judge will determine the bond. We appreciate y'all being here.
The remaining cases I have on the arraignment docket are inmates. Would you like me to call them?
Yes, sir.
Trevor Thomas.
Hello, Mr. Thomas.
Judge, this is Trevor Thomas before the court in 23 CF 1407. We're going to be entering a plea of not guilty today. Madam Clerk, has the state filed information in this case? Is it a one-count information? We would acknowledge receipt of the one-count information, ask for this to remain on the scheduled court date of September 11th. If we're able to resolve this matter ahead of that date, I'd like the opportunity to schedule this for an early plea if we're able to reach an agreement next week.
Yes, sir. Absolutely. Mr. Thomas, I'll see you no later than September 11th.
Do you have any questions for me while you're here?
Thank you, sir.
Next we have Alfred Williams. Alfred Williams. Straight up.
Judge, this is Mr. Alfred Williams Jr. before the court. The only thing that's not written on this piece of paper is that there's... So we did sign it today.
What's this?
Today is the 17th. 8/17/23.
Thomas Williams.
Mr. Williams is here in two case numbers, 23 CF 1374 and 1375. And we have reached an agreement in each of those cases in which Mr. Williams would be entering a plea of no contest as charged. He would be adjudicated guilty. He's previously been adjudicated. He would be placed on 36 months probation with standard court cost of $615 in the 1375 case and $515 in the 1374 case. a total of $250 cost of defense. Special conditions while on probation would include 48 hours community service work, no trespass, no contact with Clayton Frady, spelled C-L-A-Y-T-O-N, last name F-R-A-D-Y. He must complete a substance abuse evaluation within 30 days, treatment to begin within 60 days if recommended. Anti-theft course. Mr. Williams must maintain gainful employment or submit 5 job applications per week. Madam Clerk, the no trespasses is 829 Fairview Drive, Apartment 3, Fort Long Beach, 32547. May I approach with the plea agreement?
Yes, sir. Thank you.
No objections to the score sheet, which shows 29.6 points.
Mr. Williams, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. You can put your hand down. Mr. Williams, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, I am.
Did you sign the plea agreement?
Yes, sir.
Mr. Williams, one thing that Mr. McKinney didn't state on the record was there'll be a $40 per month cost of supervision. Do you understand that?
Yes, sir.
Do you still wish to enter the plea?
Yes, sir.
Mr. Williams, I do accept your plea. You're adjudicated guilty in both cases. You're sentenced to 36 months probation. That's to run concurrently, run at the same time between each case and count. All monetary assessments mandated by statute or county ordinance are imposed. That's the court cost, total of $250 public defender's fee, $40 per month cost of supervision. You'll need to perform 48 hours of community service work, have no trespassing at that 829 Fairview Drive, that apartment, have no contact with the victim that was named today on the record, submit to a substance abuse evaluation within 30 days from today, begin any treatment if it's recommended within 60 days from today. You need to enter and successfully complete the anti-theft course and obtain gainful employment or perform or complete 5 applications per week.
Yes, sir.
Thank you, sir. Good luck to you.
And
The next one is Jonathan Williamson.
Judge, this is Jonathan Williamson in 23 CF 1399. He only handed me one.
Williamson, Williams information.
Okay, all right. Do you have any questions? Madam Clerk, will you verify that Mr. Williams signed that plea agreement? I was doing multiple things at once. Just wanted to make sure.
Yes.
Okay. 8/17/23. Yeah, we did. Judge, Mr. Williamson at this time wishes to enter a plea of no contest as charged. The agreement calls for a withhold of adjudication in count 1, which is the felony count. In that count 1, he will be placed on 24 months probation. Counts 2 and 3 are second-degree misdemeanors. They would be adjudicate in time served. In count 1, the probation would include special conditions of no contact with Bernard Schultz, spelled S-C-H-O-L-Z, no trespass at his address, There is a $36 amount of restitution and standard court costs that would include the standard cost of supervision. May I approach?
Yes, sir. And there's a $150 public defender.
Correct.
Okay. Mr. Williamson, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, sir. You can put your hand down. Mr. Williamson, did you read the plea agreement?
Yes.
Do you understand it?
Yes.
Did you discuss it with your attorney?
Yes.
Did he answer all of your questions?
Yes.
Are you satisfied with his representation?
Yes.
Did you sign the plea agreement?
Yes.
Mr. Williamson, I do accept your plea. Adjudication is withheld. On count 1, you're adjudicated guilty of the 2 misdemeanors. You're sentenced to credit for time served on counts 2 and 3 to 24 months probation on count 1. You'll have no contact with the victim, have no trespassing at the victim's residence. Did you give that address?
Judge, I believe it is 105 Wellington Road, Fort Walton Beach, Florida 32547.
Thank you. You need to pay the $36 in restitution. You need to pay the court costs, $150 public defender's fee, and the $40 per month cost of supervision. Thank you, sir. Good luck to you.
Judge, that should be all that I have on the arraignment docket.
Okay. Did Brian Langley work there? Come on, Mr. Langley. 23 CF 1468. Mr. Langley, do you wish for me to appoint a public defender if you qualify financially?
No, sir.
Okay, you're going to hire a private attorney?
Yes, sir.
You've been handed the information, the charging document from the state that charges you with 2 counts of possession of controlled substance without a prescription, 1 count of fleeing, eluding law enforcement, and 1 count of paraphernalia. And that's why you're here. You'll need to be back here on September 11th at 9 o'clock. If you're going to hire a private attorney, do it sooner than later so they can help you. You decide you can't afford an attorney or you don't want to hire one, and you want to try to qualify for a public defender, you can get a financial affidavit from the clerk.
Yes, sir. All right.
Thank you, sir. September 11th, 9 o'clock.
Yes, sir.
Thank you. William Locke? Nope, we did Mr. Locke.
He's right here.
He's in back? Good. Yes, ma'am. 23 CF 1480. Mr. Locke. Does the state have an offer for Mr. Locke?
Pardon me?
I'm asking the state if they've got an offer for you, Mr. Locke.
Yeah, sure, now, hold on. This time, Your Honor, would be to plea as charged and adjudication of guilt, 2 years of probation. Court would reserve jurisdiction for 180 days to determine the amount of restitution. 615, court costs, a substance abuse evaluation within 30 days and to begin any recommended treatment within 60 days with random urinalysis, 24 hours community service work, and no contact with the victim.
Mr. Locke, the reason why I ask all those questions, have you been adjudicated guilty of a felony before?
No, I have not.
Mr. Locke, do you want me to appoint a public defender if you qualify financially?
No, I was in Judge Moody's court yesterday, and I was supposed to have had Scott,
Scott Pines?
Your Honor, Mr. Locke was found not indigent by the clerk's office.
yeah, so that's what's happened, and I wasn't notified by the PD office, so I've been in jail for 45 days and got no letter back from Mr. Klein's or Mr. Leonard to that regard, so therefore, I've been told yesterday in Judge Moody's court that I'm going to have to hire an attorney. I have an attorney who Mr. Klein spoke to in Bradenton, Florida,
Good.
Stephen Michaels, but he doesn't want to drive up here, so he got me one attorney, but that was Mike Flowers, However, Mr. Flowers started at one price, went back to his partner Shaw, came back with another. I said no. That's when I filed for the public defender office, and then I found out after the fact, not until going to court yesterday, that I didn't qualify.
Yes, sir.
So therefore, you know, I need to get an attorney, and so I'm not prepared to take any offer at this time, and I would like to continue this.
Okay, so what I'll do is, you are handed a copy of the information. You're charged with possession of a drug without a valid prescription, possession of narcotic equipment, and criminal mischief. That's why you're here. I do enter a denial for you, and I'll see you back here on September 11th. If you're going to hire a private attorney, do it sooner than later. If that attorney down in South Florida, you know, if they want to do preliminary work and talk to the state, and he wants to appear via Zoom, I don't have any problem with that. If we have a trial, he's got to come up here physically. But if he wants to represent you preliminarily, and he thinks he can do it, he can appear via Zoom, okay?
He can appear what, sir?
Via Zoom over the video.
Oh, okay.
Okay?
All right.
So if he's the only game in town for you financially, talk to him about doing that,
Okay.
okay?
All right.
September 11th, I'll see you then.
Okay, thank you, sir.
Thank you, sir.
All right.
Brent Millette. Brent Allen Millette, 23 CF 1486. I don't see Mr. Millette. What is this was noticed for 1:30, it's 2:16.
State requests a capias, Your Honor.
Capias of each for Mr. Millette, first appearance, Judge. Alan Maltias Carrillo, 23 CF 1412. I don't see Mr. Carrillo. What does the state seek?
Capias, Your Honor.
Capias of each for Mr. Carrillo. Did we do Nicholas Meyer? Nicholas Meyer, 23 CF 1440. That's a fugitive from justice. What does the state seek?
Your Honor, I think, if I'm not mistaken, and I've had some issues with knowing in these situations where we have a fugitive from justice.
Yes, sir.
It says that he was released, and I don't know if that means that he was picked up by, so I don't necessarily want to issue a capias in a situation where he went ahead and signed a waiver and was extradited.
So we want to continue it until,
I think, yes, and then once I can confirm that he's been picked up by whatever the out-of-state is, then I'll just announce it, I'll dismiss the case.
okay, September 14th at 1:30. Kendra Perkins. You do, Miss Perkins? Okay. Kendra Perkins, 23 CF 1466. I don't see Miss Perkins. What does the state seek?
Request a capias, Your Honor.
Capias is issued for Miss Perkins. Ronald Phillips. Hello, Mr. Phillips. 23 CF 1578.
Good afternoon, sir.
Good afternoon, sir. Mr. Phillips, do you wish for me to appoint the public defender if you qualify financially?
Yes, public defender, sir.
Okay, how much money do you make per month?
I'm out of work right now, sir, so I'm trying to find a job. Nothing right now.
How long have you been unemployed?
Since I've been out about 2 weeks.
Okay, how much were you making, how long were you in?
I was in a week.
Okay, how much have you averaged making per month over the last 6 months?
I haven't, Your Honor, I've been in jail.
Okay. Mr. Phillips, I do appoint the public defender to represent you. Mr. Cox is coming on your left. All right.
Yes, Judge, we'll be entering a not guilty and waive formal readings. I will provide my card.
Good.
And just contact that number, schedule appointments to discuss the case. Okay.
So September 11th at 9 o'clock, I'll see you back here then.
Thank you, sir.
Thank you, sir. Did we do Julio Ramos Perez?
We have, Judge, you checked it.
Hello, Mr. Perez.
How you doing?
Good, how are you? Do you have any information?
I do, Judge.
Mr. Perez, do you wish for me to appoint, let me look at this. Does the state have an offer for Mr. Perez?
Judge, Mr. Perez also has an additional case, 23 CF 1040. So based on that case, the offers an adjudication in 3 years DOC min man.
Okay. Mr. Perez, do you wish for me to appoint the public defender if you qualify financially? Is that a yes?
Yes.
Okay.
To be clear, Mr. Gates represents him on the other case, Mike Gates, that is.
Okay. And Mr. Gates was in here earlier, but he, no, watched, folks. Okay. Was Mr. Gates appointed or he was hired private?
Hired privately, Judge.
Okay. Mr. Perez, so I can appoint the public defender if you qualify financially for this case. If you want to hire a private attorney, you can certainly do that too. It's up to you. What do you want to do?
I want to pay a lawyer.
Pay a lawyer?
Yeah.
Okay. So I'm not going to appoint a public defender today. The paper that you were handed is the information, the charging document from the state. Charges you with possession of a drug without a prescription, possession of paraphernalia, and actually 2 counts of possession of drugs without a prescription. So I'll see you back here on September 11th. If you're going to hire a private attorney, do it sooner than later, okay? September 11th, I'll see you then. Thank you. Kelly Schaffer, I think, or Schaefer,
She's ready.
23 CF 1484. Can you pronounce your name Schaefer or Schaff?
It's pronounced multiple ways, sir.
Which way do you
I prefer
pronounce it?
Schaefer.
Schaefer, you got it. Ms. Schaefer, you're charged with possession of cocaine, 3rd degree, possession of narcotic equipment, resisting an officer without violence. That's why you're here. Do you wish for me to appoint the public defender if you qualify financially?
Yes, please.
Okay. How much money do you make per month?
Currently about 2,000.
Okay. I do appoint the public defender to represent you. Mr. Koch is approaching on your right.
Yes, Judge. And there was information, okay. Judge will be entering not guilty and waiver formal readings.
Okay. So, Ms. Schaefer, that means that I'll see you back here no later than September 11th. Your attorney will come see you in the jail, okay? But if you'll hold on, yes, ma'am.
For Ms. Schaefer's benefit, I want to make sure it's a withhold, 12 months probation offer with costs, substance abuse evaluation, any recommended treatment, random urinalysis, and a letter of apology to the officer.
Judge, I'm sorry.
Why don't we pass? Do you want to talk to Ms. Schaefer in the back?
Yes, Judge, please.
Here. So, Ms. Schaefer, I'll see you later this afternoon, okay? Your attorney will come back and talk to you. Did you hear what the state offered you?
Can that be repeated if you don't mind, please?
So withhold adjudication, so you wouldn't be a convicted felon as long as you complete probation like you're supposed to. 1 year of probation, you have to pay the court costs, it would be $615 for court costs. If you have a public defender in the case, it would be an additional $150. It would be $40 a month cost of supervision. You have to perform a substance abuse evaluation and they recommend treatment on that. Random urinalysis and do a letter of apology to the officer. I heard her at that time, yes, sir.
Okay. So I'll see you later this afternoon. Okay?
Thank you, Judge.
Thank you, Mr. Harrison. Who do you have next?
John Waddell.
Good, thank you.
Waddell. Straight up to that, please.
23 CF 1430, Mr. Waddell. Oh, Mr. Waddell.
How you doing, sir?
Good, how are you?
I could be better. Please excuse the parents of this traumatized veteran.
Mr. Waddell, do you wish for me to appoint a public defender if you qualify financially?
Sir, may I speak, please?
Just know that everything's being recorded, the state's back to your right. You
I
say
understand
anything
the
about
state. I respect the state attorney.
Okay. If you say anything about your case, it can be used against you, okay?
Well, I did send an application to you that I can afford my representation myself, or, private attorney or myself, sir.
Okay, so you do not want the public defender to represent you?
Well, I like to clear the record for, first of all, is that I received 100% disability 2023. 2018, I'm 50%. So I got all that back compensation.
Okay. So you've got lump sums from those back. How much did you receive?
Well, sir, in 1994, I contacted California allegation. 1994, illegal allegation. Then October 6, 2010, not guilty by reasonable sanity. I hired Nathan Prince, $5,000. He didn't do nothing. Then I came in front of you, 60 days without probation. I lost my wallet, and I want to prove that it was a false arrest under the 48-hour registration.
Okay.
And
So we're talking about money and an attorney.
when I went to first appearance, they said a bond of $5,000, which is, I understand and respect the 48 hours of registration. I'm willing to pay $650 a month.
Yeah, Ms. McKinney and I approach for just 1 second.
Yes, yes, ma'am.
I'm sorry.
No, you're fine.
At HubCitySoapery.com. Hub City Soapery.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Public defender to represent you initially until the court can determine, because you just testified or just stated that you were in the state hospital for a time?
No, first of all, I'm not, no. I said 1994 illegal allegation law applies.
Okay.
October 6, 2010, not guilty by reasonable sanity.
Yes, sir.
Then I appeared to you, 60 days credit, without probation, false arrest.
Okay. So, Mr. Waddell, I do appoint the public defender to represent you. I'll see you back here no later than September 11th. Mr. McKinney will come and talk to you.
I don't understand this. I'm saying an illegal allegation.
Talk to me for a second, okay?
So I'm have to go to county. I didn't break the law here, false arrest.
Well, I want to come to the jail, look over your paperwork with you, because if there's anything we can do on that.
But look where I'm at. I'm in AC confinement, closed confinement, where I shouldn't be. Look at my appearance.
Yes, sir.
I'm an honorable discharged vet. I respect life. I'm trying to get full custody of my daughters. I pay child $1,000 a child.
I've got to make a determination that psychologically you can go forward with the case, and I need an expert to tell me that.
So you're trying to tell me in 1994 illegal allegation law applies on a court agreement?
I'm worried about the psychological ability.
It's logical to me, illegal allegation.
I'll see you back here no later than September 11th.
September 11th.
Yes, sir.
No, I'll come meet with you, so if there's anything we can do on that end, then I'll sit down and we'll go through it, okay?
Sir, illegal allegation law applies. Can you get me out where I'm at? Look what condition I'm in.
I do want to make sure that the record reflects that I gave Mr. McKinney a copy.
I can order civil in prison term.
Yes, ma'am. Thank you. Mr. McKinney, you enter a denial?
Yes, Your Honor, we would enter a plea not guilty.
Thank you.
We would acknowledge the receipt of the state's notice of intent for HFO.
Thank you. Rachel, anybody else getting back for 1:30?
Just Mr. McClure with Mr. Klein, are you ready?
After this inmate, then we'll do Angelica Walker. Is Ms. Walker here? I don't see Ms. Walker.
Your Honor, while we're waiting for Mr. McClure, I have somebody in the gallery if you want me to call him.
Please, yes, sir.
Jimmy McDonald. This is Mr. McDonald. He is present, Your Honor. We do have a two-count information. We will waive the formal reading, enter a not guilty plea. I would ask the court to grant a continuance. Mr. McDonald is scoring 76.8 points, currently discharged. I will need to depose the alleged victims and witnesses in this case, so I would ask the court for a one-cycle continuance.
Okay. Mr. McDonald, I'll see you back here on, or no later than November 13th at 9 o'clock. Okay? Thank you, sir.
Thank you.
Cody McClure.
Your Honor, this is Cody McClure, 2020 1546. Mr. McClure has reached an agreement with the state to resolve this. At this time, Mr. McClure would enter a no contest plea and is charged. The agreed upon disposition is going to be that Mr. McClure is placed on 1 year of probation. As a condition of probation, he will perform 24 hours of community service. He would also submit to a substance abuse evaluation and any recommended outpatient treatment. He would be assessed $610 in court costs, $150 in public defender fees. Probation will terminate automatically upon completion of the special conditions, and there will be a withhold of adjudication.
Okay, thank you. Mr. McClure, if you'll raise your right hand, do you swear, please, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You can put your hand up. Mr. McClure, did you read the plea agreement?
I read it.
Do you understand?
I understand.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
He did.
Are you satisfied with his representation?
I am satisfied.
Did you sign the plea agreement?
I have signed it.
Mr. McClure, I do accept your plea. Adjudication is withheld. You're sentenced to 1 year of probation. You'll need to perform 24 hours of community service work, submit to a substance abuse evaluation within 30 days from today, begin any treatment if it's recommended within 60 days from today. You need to pay the court costs, $150 public defender's fee, $40 per month cost of supervision. Your supervision will automatically terminate upon your successful completion of all your terms of your supervision.
Your Honor, Mr. McClure was going to ask the court to consider waiving the cost of supervision for 3 months. He has been in jail for about 45 days. He does need to get a job and get his identification card.
Mr. McClure, how much money were you making before you went into jail?
None at all. I didn't even have a job.
I do waive the cost of supervision for the first 3 months of your supervision. Thank you, sir.
That's all the inmates except for Schaefer, who Mr. Koch just went through.
Gotcha. Mr. Kleins, anybody else? You have anybody else in the gallery that's here for the 1:30 arraignment docket?
Judge, I do have one late show, Ms. Chantel Paddock, who's present approaching, Your Honor.
Thank you.
Sorry for being late, I was in the name.
I'm glad you're here.
Yes, Judge. Ms. Paddock informed me that she is going to seek private counsel. I did give her my card. I wrote down the next court date, the 9/11 date, to tell her future attorney. If not, she has my number to contact me, make an appointment if her plan is fault.
Okay. But you were previously appointed, right?
Yes, Judge, so we will be entering not guilty today, waiver formal readings, and keep this set for the 9/11 date.
Okay.
Please.
Ms. Paddock, I'll see you back here on September 11th at 9 o'clock. If you're going to hire a private attorney, do it sooner than later so they can help you, okay? Thank you, ma'am. Thank you, sir.
Sarah Jenna Linton or Carol Litz?
Called for Ms. Linton and Ms. Litz numerous times.
What is the state seat?
KPS, Your Honor.
KPS will be issued for both of them. Anybody else in the room? Mr. Koch? Is he out? Is it here now?
Yes.
Is that a real? Okay, yes, ma'am.
Mr. Matias Correa.
Good seeing you, sir.
Your Honor, James Ryder.
Yes, sir. Mr. Ryder, if you'll raise your right hand.
Do you swear or affirm that you will make an accurate, complete, and impartial interpretation from the Spanish language into the English language and vice versa relative to the files now under consideration for the court?
I do. That was very good. Thank you.
Okay. So it's 23 CF 1412. The case is withdrawn from Mr. Carrillo.
Que era un impuesto no de arresto porque no estaba antes, pero por la confusión quitaron eso.
The reason why you're here is you're charged with possession of cocaine, third degree. Do you wish for me to appoint a public defender if you qualify financially?
Yes.
How much money do you make per month?
¿Cuánto gana usted al mes? ¿A la semana? ¿Cuánto? Your Honor, the interpreter said, I can't really say, and the interpreter said, well, 1 week for a week. 1 week is $600.
Okay. So that'd be $2,400 a month? Is that what you make?
¿Usted gana 2,400 al mes por ahí? Yes.
I can't appoint a public defender to represent you based on that amount of money. If you wish to fill out a financial affidavit, you can fill one out with the clerk's office. If the clerk says that you don't qualify for the public defender because you make too much money, you can appeal that to the judge, and the judge has a little more leeway than the clerk. It'll cost you $50 for that application fee. But in that financial affidavit, if you load it up with all your expenses and everything that you financially, then the judge may look at that and say you qualify for the public defender anyway. But today, I just can't say based on your representation that you qualify for a public defender. So you're charged with that possession of cocaine, third degree. I'm not appointing a public defender at this time. If you don't qualify for the public defender, you'll need to hire a private attorney, or you'll be representing yourself. I will see you back here on September 11th
Nos veremos
at 9 o'clock.
11 de septiembre a las 9 de la mañana. Your Honor, after the interpreter, after I catch the other case, Your Honor, with the court's permission, I'll go down with the defendant to show him how to do that and help him with that.
That'd be great. Thank you so much,
Thank you, Your
Mr.
Honor. Si usted pide que así, en su caso, y después me voy a bajar con usted para llevar. Thank you.
Yes, sir. What's your next case?
Your Honor, I believe it's Mr. Maldonado. Maldonado Ayala.
Is that going to be a longer hearing?
It's an entry between,
Okay.
but
Yes,
it's
sir.
going to take a few minutes because it's a pretty long conversation.
Understand. Yes, sir. Let's go ahead.
Can I bring him up? Thank
Please.
you, Your Honor.
Mr. Lewis, then I'll do your case after this, okay? Thank you.
Good afternoon, Judge. Tim Shaw and Jay Patel for Jose Rafael Maldonado Ayala, case number 21 CF 459. At this time, Mr. Maldonado Ayala would withdraw his previously entered plea of not guilty, tender a plea of no contest. The terms are, Judge, counts 1 through 19 and 21 through 22 would be an adjudication of guilt. Count 1 would be 5 years of sex offender probation. Counts 2 through 19 and 21 and 22, 5 years sex offender probation consecutive to count 1. $515 in court costs, $151 crimes against minors fee, sex offender designation and all statutory requirements associated with that status, including counseling, GPS while on supervision, no contact with minors except his minor child, AUL, born on June 1, 2022, as previously ordered by the court, until completion of sex offender counseling and completion of statutory requirements, no internet capable devices, forfeit seized devices containing any child sexual abuse material or suspected child sexual abuse material, curfew of 7 p.m. to 7 a.m., adjustable by probation for work purposes. Count 20 will be no price. Parties agree the state will return any electronic devices seized that do not contain child sexual abuse or suspected child sexual abuse material. Defense will provide state with a proposed list of devices within 60 days from the date of this plea. Due to the defendant not being able to possess internet-capable devices, the devices subject to return shall be released to the defendant's stepmother, Gabriela Mendoza. This plea and sentencing agreement is a downward departure based on a legitimate, uncoerced plea bargain. May I approach, Judge?
Yes, sir. Thank you, sir. If you'll please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. You can put your hand up. Are you currently under the influence of any drugs, alcohol, or medication?
No.
Have you ever been treated for any mental illness or emotional disturbance, or are you suffering from any of those at this time? How far did you go in school?
Bueno, estudié en mi país, llegué hasta el colegio.
I studied in my own country and I got to college.
Was the plea agreement read to you in Spanish?
Yes.
Do you understand it?
¿Usted lo entiende? Yeah, yes, I understand it.
Did you discuss it with your attorneys?
¿Usted se comunicó con su abogado de esa? Yes.
Did they answer all of your questions?
¿Le contestaron todas sus preguntas? Yes.
Are you satisfied with the representation?
Yes.
Did you sign the plea agreement?
Yes, I signed it.
Do you understand that if I accept your plea, that you're waiving your right to a trial by jury?
Yes.
There was one statement that Mr. Gates, and I just, thank you, Mr. Shaw. Mr. Shaw read that I wanted to clarify. When it says no contact with minors, and then it has the exception for your child. No contact with minors until completion of sex offender counseling and completion of statutory requirements. Correct me if I'm wrong, Mr. Shaw, but doesn't the court have to enter an order before your client could have contact with other minors?
And Judge, we would file a motion for him to come back and do that.
He'll need to get his risk assessment and comply with probation requirements before he can petition the court for any contact. There's no contact until he's done his risk assessment.
And I did that for the benefit of the defendant. Just upon you completing that, you still can't have contact with any minors until a court order is entered that allows that. I do accept your plea. I find that you're alert and intelligent, that your plea is freely and voluntarily entered, and that there is a factual basis for the entering of the plea. You're adjudicated guilty of counts 1 through 19 and counts 21 and 22. Count 20 is dismissed. You're sentenced to 5 years sex offender probation in count 1, in counts 2 through 19 and 21 and 22. You're sentenced to 5 years sex offender probation consecutive to count 1. You'll need to pay the court cost, $151 crimes against minors fee. You'll be designated as a sexual offender, and you'll have to do all the all the statutory requirements associated with that status, including counseling, wear a GPS monitor while you're on supervision, have no contact with any minors, except you may have contact with your minor child, initials AUL, born on June 1st, 2022. And again, the no contact with other minors until after a court has entered an order after you've completed sex offender counseling and completion of the statutory requirements. You'll have no internet access, no internet capable devices. Those devices are forfeited. The devices that contain any, says CSAM.
Child sexual abuse material.
Thank you. Any of those materials is forfeited. Those devices that don't have those items on them will be returned to your family member that's mentioned in here. You have a curfew from 7 p.m. to 7 a.m. and probation can adjust that for work purposes. And the court does acknowledge that it's a downward departure based upon the plea agreement. You do have 30 days to appeal this judgment and sentence. If you wish to appeal, it must be in writing. If you cannot afford an attorney to represent you for that appeal, one may be appointed for you. Do you understand your appellate rights?
Yes, I understand.
Thank you, sir.
Muchas gracias, señor.
Thank you.
Thank you, Judge. Thank you, Your Honor.
You'll call us back.
Yes, sir. Thank you. Thank you, Mr. Ed.
Thank you, Your Honor.
Judge, was there a score sheet attached to that?
Yes, ma'am, there is.
Okay.
Mr. Lewis?
Yes.
Mr. Lewis, are you represented by someone? Or are you?
No, sir, I'm not.
Okay. All right, Charles Wesley Lewis, 21 CF 249. And it says motion hearing, but, okay, wait a minute. Here we go, got it. Okay, so you've done a motion to modify your probation. It says that you were placed on probation on January 11th of 2022. You're seeking to terminate that.
Your Honor, the state's not going to have an objection to this.
Okay. Mr. Lewis, then your motion to terminate your supervision is granted. So your supervision's over, okay?
Okay, thank you.
Thank you. Thank you, Mr. Lewis.
Is there anything I need to do or any steps I need to take?
No, sir, not that I'm aware of. I'm going to sign the order. I believe that you gave me a proposed order. You did. I'm going to sign that right now, okay?
Okay.
Thank you, sir.
Thank you.
You're welcome. Okay, on the remaining cases, where do we want to go? Shortest to longest, Mr. Nopes, you ready?
Judge, I've got, that was Spence.
Judge, I have Ms. Schaefer from the 130 docket.
Okay. Okay, Ms. Schaefer?
She's
Oh, okay.
Oh, yes. Yes, sir, Ms. Schaefer, I apologize.
Almost, Mr. Nopes. Hello again, Ms. Schaefer.
Yes, sir.
Yes, sure. And I was just appointed by, just made briefly, you do have bond in possession of cocaine. It's $2,000. And the other two charges that are misdemeanors, there's no bond needed, so you're only held on one count for $2,000 bond. Does that answer your question?
Yes.
Okay.
And what about how much was found or what was found or where it was
Oh, we
found?
will, nothing about the facts of the case, but her concern was about bond, Judge.
Yes.
And we'll enter a not guilty plea, wait formal readings, Judge, and keep this set for the 9/11 date.
Okay. So, Ms. Schaefer, you're turning down the withhold of adjudication and 12 months of probation?
Yes, sir.
Okay. It's your call. Just wanted to make sure that you were doing that.
Yes.
Okay. So then I'll see you back here on September 11th, okay?
Yes.
Thank you, ma'am.
Thank you, Judge.
Sir. Okay, now, Mr. Nopes.
Correct. All right, if you don't get out. Yeah. Schaefer, that's what, I'll be in touch, if you don't get out. Yes. Just in case. Yeah.
Judge, I had been appointed to Mr. Spence's case, I guess, at the end of June.
Yes, sir.
I met with him, the state sent me everything. Judge, I don't necessarily think we need to proceed to withdraw his plea at this juncture. He needs to be evaluated, and the process with the JAC is, if I don't get it right, I've got 5 cases that I got one of them right, they say, 4 of them not right, and it's a nightmare to untangle. Tomorrow, I'm going to put together the motion to have him evaluated for You know, the mitigation circumstances.
Yes, sir.
But there's step by step, and if you don't get the steps right, then they'll deny it, and then there's a problem where getting people paid and the rest of the nightmare. So that's tomorrow's job for me. But I think, I know you want to put it on a day, but I think we could proceed to sentencing in the future once we have the evaluation done, but I've got to get the documents put together and get the JHC to say it's okay to move forward.
So how long do you want to continue?
Judge, honestly, I think just to keep a hold on it, I mean, I'm fine to put it off for a month and then let's see where we're at, how far we've gotten. And if I can get the JAC on board by the next week, I can get Dr. Harper to go see.
Okay, so if you can, okay, there's no way that you're going to get it pulled off by next week, right? As far as the evaluation?
No.
Okay, so you want it September 14th or October 9th?
Let's just say September 14th.
Okay. So, Mr. Spence, I'll see you back here no later than September 14th at 9 o'clock. Okay. Thank you, sir.
Thank you, Judge.
Thank you, Mr.
Have an excuse?
Yes, sir. Absolutely. Thank you. Okay, then, from shortest to longest? Yes, sir.
Judge, I've got a Lucas Simpliciano, who is president of the courtroom, and 3 case numbers. This is a very short case.
Yes, sir.
Judge, he is here in 3 cases, 21 CF 2961, 21 CF 3277, and 22 CF 227. And he is coming back to us from Florida State Hospital. And I believe that the appropriate reports were filed in the court record where they found him competent to proceed. Once I saw that.
Hold on one second. Let me look at that.
There's a confidential forensic evaluation.
Yes, sir. And I'm flipping through that, and I did highlight some of that. Yes, sir.
So the first thing to be done would be to find him competent to proceed and place him back on the docket.
I do find Mr. Simpliciano. Okay, thank you. Competent to proceed.
And when I saw him coming back and I reviewed the case, I did notice a conflict and filed a motion to withdraw on August 8th. I don't know where the order went.
I do see the motion. Yes, sir.
That has been filed in all 3 case numbers. So if the court grants that motion, then he would have RCC, and then we would be requesting the next available court date, which would be pretrial on 9/11.
Okay. So I do grant the motion to withdraw. My note to myself was, when did I see a proposed order? Because I don't see that, but I do grant the motion to withdraw. Any advantage? Well, since it's regional conflict counsel, your motion granted to withdraw. Also, I'll see you back here no later than September 11th at 9 o'clock, okay? But your new attorney will get in touch with you.
Okay. Well, Judge, I'll provide their contact information to Mr. Simpliciano before he leaves the courtroom.
Okay. Thank you, sir.
Thank you.
Okay. Any other shorter hearings? Yes, sir.
Judge, we have one plea.
Okay, please, Mr. Patel.
Good afternoon, Judge. Tim Shaw and Jay Patel for Donald Peter Carraggio Jr., 21 CF 2651. At this time, Mr. Carraggio would withdraw his previously entered plea of not guilty, tender plea of no contest as follows. Counts 1 through 13 and 21 through 29, there would be an adjudication of guilt. In exchange for this plea, the state dismisses counts 14 through 20. As to count 1, 5 years DOC, counts 2 through 13 and counts, 2 through 13 and 21 through 26, 2 years DOC consecutive to count 1, but concurrent between each other for a total of 7 years DOC. Count 27, 5 years sex offender probation consecutive to counts 1 through 13 and 21 through 26.
Count 28, 5-year sex offender probation consecutive to counts 1 through 13 and 21 through 27 for a total of 10 years sex offender probation. 515 court costs, 151 crimes against minors fee, sex offender designation, and all statutory requirements associated with that status, including counseling, GPS while on supervision, no contact with minors until completion of sex offender counseling and completion of statutory requirements, and the judge enters an order to that effect. No internet capable devices, forfeit seized devices containing child sexual abuse material or suspected child sexual abuse material, curfew 7 p.m. to 7 a.m. adjustable by probation for work purposes. The parties agree the state will return any electronic devices seized that do not contain child sexual abuse material or suspected CSAM material. The defense will provide state with a proposed list of devices within 60 days from the day of this plea. Due to the defendant not being able to possess internet-capable devices, the devices subject to return shall be released to the defendant's wife, Kelly Coraggio. May I approach you?
Yes, sir. Mr. Coraggio, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. Mr. Coraggio, are you currently under the influence of any drugs, alcohol, or medication?
No, Your Honor.
Have you ever been treated for any mental illness or emotional disturbance, or are you suffering from any of those at this time?
No, Your Honor.
How far did you go in school?
Part of the way through college.
Did you read the plea agreement?
Yes, Your Honor.
Do you understand it?
Yes.
Did you discuss it with your attorney?
Yes, Your Honor.
Did they answer all of your questions?
Yes, they did.
Are you satisfied with their representation?
Yes.
Did you sign the plea agreement?
Yes, Your Honor.
Do you understand that if I accept your plea, that you're waiving your right to trials by jury?
Yes, Your Honor.
Do you believe has anyone forced, threatened, or coerced you into entering the plea?
No, Your Honor.
Has anyone promised you anything other than what Mr. Shaw stated today on the record and what's in your written plea agreement?
No, Your Honor.
The other side of that, has Mr. Patel or Mr. Shaw told you, Mr. Coraggio, if you don't enter this plea, you shall be sentenced to 15 years in prison or any other definite sentence?
Yes.
They told you if you don't enter this plea, you're going to prison for 15 years?
I'm not exactly sure of that number, to be honest.
Okay. The reason why I ask that is, if someone's told you, if you don't enter this plea, you are going to be sentenced to something. I can't tell you what I would sentence you to if the jury found you guilty. So I want to make sure that someone has not told you, if you don't enter this plea, this is what you shall be sentenced to. Because nobody knows that at this point. So do you understand?
Yeah, I understand.
I want to make sure that no one's coerced you into entering the plea.
No, Your Honor.
Any questions for the court or your attorney or the state about that?
No.
I understand you could be sentenced to the maximum of 15 years if you didn't enter the plea, right? You understand that?
Yes.
Mr. Coraggio, I do accept your plea. I find that you're alert and intelligent, that your plea is freely and voluntarily entered, that you understand the nature of the charges against you and are represented by competent counsel. You're adjudicated guilty. By the way, probably Court Smart picked up my under the breath when Mr. Shaw was saying about explaining things. He mentioned something and he said, for a total of 7 years, and under my breath, it was an excited utterance, I said, good. The good wasn't that you were going away for a total of 7 years, but that it expressly said, because of the concurrence and successive and all those things, it said that the total was 7 years. So counts 1 through 13 and 21 through 20, adjudicated guilty. In exchange for the plea, the state dismisses counts 14 through 20. Count 1, you're sentenced to 5 years DOC. Counts 2 through 13 and 21 through 26, you're sentenced to 2 years Department of Corrections, consecutive to count 1, but concurrent with each other, for a total of 7 years DOC. Count 27, you're sentenced to 5 years sex offender probation, That's consecutive to counts 1 through 13 and 21 through 26. Count 28, 5-year sex offender probation, consecutive to counts 1 through 13 and 21 through 27, for a total of 10 years sex offender probation. $515 in court costs, $151 crimes against minors. You will be designated as a sex offender, and all statutory requirements associated with that are imposed, including counseling, GPS while on supervision, no contact with any minors till a completion of a sex offender counseling and completion of statutory requirements, and also the entering of an order by the court. You have no internet capable devices, not go on the internet. Any devices that contain any child sexual abuse materials are forfeited. If there's any devices that do not contain that, then they'll be released to your wife, and your attorneys will give a list of those, that hardware basically, to the state. Mr. Coraggio, you do have 30 days to appeal this judgment and sentence. If you wish to appeal, it must be in writing. If you cannot afford an attorney to represent you for that appeal, one may be appointed for you. Do you understand your appellate rights?
Yes, Your Honor.
Thank you, sir.
Thank you. Yeah, I have nothing else, man.
Yes, sir. Thank you.
Judge, we have one more hearing. I think it'll take about 10 minutes.
Why don't we, I think we've been working over an hour and a half. We'll take a short recess unless there's anything else.
Oh, no, Your Honor, I was just gonna, with Mr. Klein's, I have nothing else, maybe excuse me.
Yes, sir. Thank you so much.
Me as well.
Yes, ma'am.
Thank you, Judge.
Okay, so we're in recess for 10 minutes, then we'll come back and finish up the afternoon.
All rise, please.
Hi, I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Backbone Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Fat Boy's Juicy Beef and Tasty Bird is located at 482 North Wilston Street in historic downtown Crestview, just 1 block from the courthouse. We open at 10 a.m. with amazing lunch specials until 2 p.m., serving incredible burgers, wings, sandwiches, and appetizers. Join us for happy hour Monday through Friday from 3 p.m. to 6 p.m. Hope to see you soon.
Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
Congratulations, Crestviews' very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV Preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045. Days Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at daystirepros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.agent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hi, I'm Amanda Gaskin with Briarpatch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Fat Boy's Juicy Beef and Tasty Bird is located at 482 North Wilston Street in historic downtown Crestview, just 1 block from the courthouse. We open at 10 a.m. with amazing lunch specials until 2 p.m., serving incredible burgers, wings, sandwiches, and appetizers. Join us for happy hour Monday through Friday from 3 p.m. to 6 p.m. Hope to see you soon.
I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
It's Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 and
Felony plea day docket, Angelica Walker was on the unrepresented list.
Okay. What are you seeking?
Habeas judge.
Habeas will be issued for Ms. Walker.
Did you ever call Jillian Watson, Madam Clerk, also on the arraignment docket? Okay.
Your Honor, I have one also, last name, Hello Peta, first name Angela. I don't know if that was addressed when I was talking. We have it, okay.
What is the state seeking regarding this parapeta?
Angela Pelopita.
Pelopita, okay.
Habeas judge.
Habeas will be issued for her, and the first appearance judge will determine the bond.
Yes, sir.
We have Mr. Spradlin on the docket for a motion to suppress hearing.
Yes, sir.
Not sure what the status is of that.
Judge, Mr. Crowley is President Pro Tem if we want to address it now.
Sure, please. Mr. Spradlin, how are you? Good. Let's figure out what's going on, Mr. Crutch.
Judge, the defense is ready to move forward with the motion to suppress that's set for today.
Okay?
To be clear, I want to make sure that on the record at this point, the offer is a guideline sentence of just over 16 months. That offer is going to be withdrawn if we proceed forward with the motion to suppress. No depositions have been done in this case. There was nothing attached to the motion to suppress. So at this point, the state's position is the burden is still on the defense to provide a prima facie case before the burden shifts to us to provide witnesses and or other evidence.
Okay. So, Mr. Spratland, do you understand that the state is going to withdraw its offer to you if you go forward with this motion to suppress?
Not exactly, do I understand it?
Mr. Koch, why don't you, on the record, why don't you explain what the offer is from the state, and then if you need to step away from the mic, you can.
And to be clear, I had expressed this to Mr. Koch after he had filed the motion to suppress, and I had received the notice of hearing. I had sent all of that information to him.
I mean, part of withdrawal sounds great. I'm not exactly sure what I'm hearing now.
Okay.
If I may, Judge.
Please.
Is Mr. Spradlin, around 1 o'clock, now we're talking about the offer in this case, the 16.4 months, the DOC?
Yes.
That was the current offer.
Mm-hmm.
And you said you had no question, you understood that was the offer.
Yes.
And then I told you, if we move forward with that motion today, that offer is going to be taken away.
Well,
Okay, hold on. Yeah, I don't want him to say anything on there. Okay, I just wanted to make sure that you understood that, and then y'all can step away from the microphone and decide. Mr. Spradlin, my job isn't to talk you into anything. I just want to make sure that you understand what the state was saying, is they're going to withdraw that 16.4 month offer in prison if you go forward with this motion, and if you say, that's fine, I want to go forward with the motion, but talk to your attorney first away from the mic before you decide.
Thank you, Judge. We'll step outside about 5 minutes.
Okay, thank you. Mr. Patel, you ready?
Yes, Judge. Good afternoon, Judge. Jay Patel and Tim Shaw on behalf of Brett Stephen Bay, 21 CF 653 and 21 CF 1136. Judge, we're before the court on the defense's motion to exclude the state's Category A witness, Jason Stewart Matthews. Has the court had the benefit to review our motion and the attachments?
I have.
Judge, based upon the issue is pretty self-explanatory in that we are not in a position to move forward with this case without having the opportunity to depose this essential witness.
To the state?
Judge, we have been working to try to locate this witness quite extensively. At this point, the witness is, I do agree with the defense, this is an important witness in the case. We finally, 2 days ago, which it's not that we put it off to the last minute, we've been working on this for months and months and months, but I think we finally made a little bit of traction on trying to locate him. We're able to get in touch with his most recent employer, and we're able to have a conversation with him. And so I think there's an opportunity that we could find him very soon, based on the information that we were getting from, his name was Craig Hamilton, Judge. At this point, the state will request a continuance of the motion to exclude the witness. The expectation is if the motion was granted, then this witness would not be available. And with the chance that we may actually find him sooner rather than later, then as important as the witness is, I think that it would be beneficial to even both sides that this witness is located.
Okay, so what is the criteria that the court has to find to rule for or against this motion? And what do I have to find?
Well, we're asking for a continuance at this point.
I understand. What do I have to find to grant your motion for continuance over the motion to exclude? Is it undue burden? Is it, any buzzwords that I need to find?
Well, I think in this particular case, Mr. Bay is on bond, so I think that the delay would not be something that would be overly prejudicial to Mr. Bay at this point.
Thank you. Mr. Mattel?
And Judge, I completely disagree. I know that we've been given a hard time by the court to get this case resolved. We've been given a hard time by the state to get this case resolved. Mr. Bay wants to get this case resolved. We have been actively trying to get this guy for almost 18 months. I would love to know what the state has done in the since I filed this motion, because I filed this motion
May 31st.
Yeah, so months ago, as to what has been done in the last few months. Because frankly, there's an email that we got that I attached that said that, and I don't know whether it's Scrivener's error, that they do have a working number or that they don't have a working number, but in any event, we are prejudiced in that Judge Stone put some very strict bond conditions on my client. So even though he's out of jail, he has very tight parameters. He's basically on house arrest. And frankly, our client has complained to us numerous times, I want to get this case over with. If this guy's not going to show up, I want y'all to file a motion and the judge needs to make a decision. We agree with him.
Okay, so what are if the court's going to grant the state's motion to continue this until September 14th, what are the conditions of the bond that you would seek to address?
Judge, if I have a moment,
Yes, sir.
I didn't expect you to ask that question, if I'm being honest. Judge, we'd ask that, and I'm looking at the document, I don't know what it's filed in the record, but it's signed by Judge Stone on May 18, 2021, order on the state's motion for pretrial detention. It states 6 items. The first one is a $500,000 cash or professional bond. The second is shall be placed on pretrial supervision, intensive reporting. 3 is a GPS monitor. 4 is shall be placed on house arrest sanctions monitored by pretrial services. 5, pretrial services shall confirm the defendant's address before release from jail. 6, no contact with the victim's family or witness in this case. We'd be asked that the house arrest sanctions be removed.
To the state?
I don't necessarily have a problem with removing the house arrest sanction at this point, Judge. I think with the length of the case and pretrial services still being a part of the case, I don't necessarily oppose that.
Okay. Mr. Patel, go ahead. Yes,
I also have another idea that the court may be inclined, the state may stipulate to this idea about if the court's going to grant the continuance and allow the house arrest to be removed and set the case for like September, whatever that date was, 14th, to issue a writ of bodily attachment for this witness.
Okay. First off, on your motion to exclude, it's denied. However, the court does remove the house arrest sanctions from the bond conditions. I think that was realistic, you asking for that, Mr. Patel. I appreciate the state. Their response to that, the other terms of the bond will remain in place. As far as issuing a writ of bodily attachment, do I have that ability to do that for somebody that's out of state?
I don't know the exact date, to be honest with you, Judge. There was a deponent during our depositions that indicated that he was actively avoiding any part of this case, and that he was local. So I don't know that he's out of state. But in looking at some of the case law, I think the court has limited ability to rule on this issue. One is exclusion. Two, two would be a writ of bodily attachment to secure that he's here, and then at that point we can serve him. In a manner to where the court can hold him in contempt. Because the problem is you can't even do an order to show cause because we can't even get service for the deposition, much less service for the order to show cause, right?
Right.
So again, we're just trying to get the case moving.
I understand. To the state?
Judge, the writ of bodily attachment would then mean that the motion to exclude witness was granted, and then that would be the relief that you would be issuing to the defense. So at this point, we're just asking to continue the motion at this point.
Okay. The motion to continue is granted. The hearing is continued until September 14th at 2:30. Mr. Patel, if you'll give me an order removing those house arrest sanctions.
I will, Judge.
That can be acted upon with the minutes.
Okay, and so it's not that this was denied, that this motion is now continued.
Correct.
Okay.
Yes, sir.
Do you want it removed from the 9/11 pretrial?
Yeah, we can leave it on. I think one of the two of us has got to be here anyways.
Okay. Good question. Good. Okay, thank you.
Thank you, Judge.
I do have one other question before you need to leave. For Mr. Coraggio, he pled to count 29, but it didn't say on the sentencing agreement what is happening with that count. It doesn't state whether it's part of the DOC sentence or part of the probation. It's not gross.
Can I see the plea agreement? May I approach it?
Yes, sir. I wouldn't write on the original plea agreement if your client's not.
He's still here.
He is, but he's downstairs and he'll get back
That's fine.
If you want to modify it. Yes, sir. Okay. Yes, no.
I'm sorry, so what's good, because I'm going to have to relay this to.
So count 29, pled to count 29, which is the use of the 2A.
Can I look at it and see?
We're just making it concurrent on the probation.
It's been a while. Okay. Mr. McKinney?
Yes,
What do you want to do there?
Jennifer Wilson.
Ms. Wilson?
Ms. Wilson?
Yes, sir. 23 CF 424. Good afternoon.
Yes, Your Honor. We're here for sentencing for Ms. Wilson. I did provide a sentencing letter. There's been an outpouring of support for Ms. Wilson. I understand that this is a driving while license suspended charge. It's an F3L1. I still received an outpouring of support from the community related to Ms. Wilson. In fact, she does have members of the community here in the courtroom that wanted to address Your Honor before passing sentence.
Okay. You want to call them as witnesses?
Yes, Your Honor.
Come to the stand.
Very briefly.
Please stand up in this chair, face the clerk, raise your right hand.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do. You can have a seat. Thank you. You're going to talk right into this microphone. There you go. You can move it if you need to.
Okay.
Ma'am, could you please state your name for the record?
Jennifer Day.
And how do you know Ms. Wilson?
I met Jennifer about a year ago.
when she walked into AA, she came into Alcoholics Anonymous to attend her first meeting, and I happened to be there.
And can you explain to Judge Brown what you know about Miss Wilson?
Yes, so I've actually watched a beautiful transformation with her. She came in to the rooms a year ago, the very first day, and because I've kind of been in her shoes, you know, we connected. I'm a mother, and over the past year, I've got to watch her transform. I'm sorry. And so it's been incredible. So, you know, she's used her experience to help other people, you know, and so she's done amazing things with the AA program and in the community. You know, she helps so many people. She's a wonderful mother. And so I would love for her to have that opportunity to continue to do well and to be that mom for her kids. You know, she has to have the ability to drive to be in her children's life. And just like I said, the incredible transformation, it's been beautiful. It's been a privilege. It's beautiful to watch her help other women that are in her same shoes. So it's pretty amazing. I appreciate the opportunity to speak on her behalf.
State, have any questions for Ms. Day?
No, Judge.
Thank you, Ms. Day. Thank you for being here. You can step down. Ms. McKinney.
Stand right in front of the chair, face the clerk, and raise your right hand.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
You can have a seat. Speak right into that microphone. Move it if you need to.
Sir, could you please state your name for the record?
Rory Harding.
And how do you know Miss Wilson?
I'm a behavioral technician at 12 Oaks Recovery Center. I met Miss Wilson the first time when she arrived there and have since grown to know her after the fact through her involvement in AA and everything that she does with that.
Can you explain to the judge a little bit about your background?
I've been working for 12 Oaks for 5 years. It was my opportunity to give back to the 12-step program that saved my life. I currently have over 38 years sobriety, and part of what we do is giving back to the people coming in. And working at 12 Oaks, we have a lot of clients that come through, and it's very easy to see who's there to get better and who isn't. And right off the bat, Ms. Wilson was asking a lot of questions of the whys, the whats, and the wherefores. And last year she celebrated a year, which puts her in a very unique group. She's 3% of the people that go through a 30-day program that make it a year. And I fully expect with what she's doing now in the community with AA, taking back 12 Oaks AA meetings, you know, on her own time, getting there however she can get there, doing meetings on Beale Street, speaker meetings, chairing meetings, and most of all, taking care of people that come through the door that are new.
Is everything that you just told Judge Brown about the things that she's doing now, is that court order, or is that something she's doing on her own?
No, that's what we call doing the program, being part of the program. What we do at 12 Oaks is we give you the tools. I don't help you use them, other than to tell you, this is what you need to read, this is where you need to go, and this is what you need to do. Past that, it's all on them, and she has done everything and then some.
I have nothing further.
To the state.
I don't have any questions, Judge.
Thank you, sir. Thank you for being here.
Thank you. One more, Judge.
Just stand right here, face the clerk, and raise your right hand. Stand
Okay.
for me, sir.
Oh.
Yep, face the clerk.
Yeah.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Mhm.
You can slide all the way up to that microphone.
Okay.
Sir, could you state your name for the record?
Jonathan Dial,
And how do you know Ms. Wilson?
a little over a year now.
And can you tell the judge about your experience in knowing Ms. Wilson?
I'm also in AA and NA mostly, but I'm real involved. I've been involved since the early 90s, and by real involved, I mean I go to a lot of meetings. I've taken people in my house for about 30 years. I go to jails and prisons. I do a lot. I'm real involved. And I've probably dealt with thousands, tens of thousands of people over the 30 years, and every once in a while, you meet someone like her. Usually it's really frustrating and it's disappointing and it's, you're pushing people to do stuff or almost cajoling, pleading, and every once in a while you'll get a gin, and she's the one who wanted to go to meetings. She wanted to go work with a sponsor. She's the type that when a young person is in there, young girls, you can tell they're scared and emotionally, and they sort of break down. Jen's the first one to go across the room and comfort them and take them outside and talk to them. Like before a meeting, she's always talking to the young people. She's already been a sponsor in 2 or 3 or 4 people that I know of. And a lot of heavy-duty stuff happens in life, and she just was dealing with her father who was very ill. And I was really scared that this might be something that would be a little too much. She doubled up on the meetings, she doubled up on calling people, she doubled up on everything, and she picked up her year. Her father did pass, and she's real involved, and that's just such a rarity. I'm really glad that every once in a while, there's a lot of magic and a lot of tragic. Like I've said goodbye to over 200 people since I've been in AA and NA, and every once in a while, there's one of the magic ones that really want to change and really want to be a mom, and
Is Ms. Wilson still involved today in these programs?
I'm sorry, what?
Is she still involved today?
Oh, called me this morning and asked me if I would take her to the meeting, and I did, and then she asked me if I'd be in the court, and I said I would. She just started, she's she's trying to get a meeting like where we live, because there's not one right where we live. She's trying to get friends of ours that we know in the community to let her use the restaurant or, to meet there. She's very involved. And I don't think this is a temporary thing either. Like I see that a lot. People are just trying to get out of trouble, trying to get out of the heat that they're in. I think this is a whole life change for her. It's very rare. It's really a joy to be a part of.
I have no further questions.
Did they say any? No. Thank you, sir.
Judd, I'd like to ask you questions of Ms. Wilson.
Ms. Wilson, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, ma'am. You can put your hand.
You've heard the testimony here in the courtroom, and I'm sure that you are aware of a lot of the letters that were sent to me that I provided to the court.
I've read all of those, yes.
Can you explain to the court why you remain so involved in AA and NA?
It saved my life. I was raised in an alcoholic home. My mom died in the disease. Unfortunately, I did not really put the correlation that I would also have the disease. As you know, I have the record of 2 DUIs. I unfortunately was forced on probation and still drink on probation, and just got out of the trouble and stayed in it. And by the grace of God, I had a moment of clarity and surrendered and self-admitted to rehab, graduated. As Jen said, I went straight to straight to a meeting, and I found serenity in those rooms, the relationship with God, and finally with other people. I had no connection before. I was definitely an awful mother, and AA has redeemed a lot of that in the year. So I definitely owe it to AA to stay and give back.
Is it your goal, regardless of whatever the sentence is, to remain involved in these programs?
Absolutely.
Is that just part of your life at this point?
Absolutely. However, the service work would be easier, of course.
So if we look at this case, this relates to your license that was suspended because of the DUI. Is that correct?
No, still, yes. I could have had the hardship and financially so when I went to rehab, I was unemployed for several months. I'm still in debt from that. It's a debt I want to assume. It saved my life, but financial insecurity has been a part of my story for sure.
Were you eligible for a hardship license at the time that this
Yes.
driving while license suspended occurred?
Yes.
Can you tell the judge why you were driving on that day?
I have 3 children. My middle child, who just left for college this morning, was the driver around in the family, and he was supposed to take the youngest son, who just turned 14, to a birthday party. As I guess trying to be a jerk or something, he wouldn't take him. So I did.
And that's when you were arrested for the driving while license suspended that we're talking about here and,
Yes.
and before the court for sentencing.
Yes, and it is the excuse I gave the officer. I didn't lie.
Okay. No further questions from Ms. Wilson?
State, any questions for Ms. Wilson?
No, Judge.
Mr. McKinney, argument?
Judge, it's uncommon to be in my situation here with a client that has such an outpouring of support, even in a case related to driving while license suspended like we see. That's not something I normally see in the courtroom. That's the reason for the uncommon request in asking the court just to withhold adjudication and impose court costs in this case. She has done probation previously. She is maintaining her sobriety. She is active in the community, and I believe that she's going to remain active in the community regardless of whether or not this court places her on probation or not. This was an incident where she shouldn't have been driving, and she was. She's never been convicted of a felony. So we're requesting a withhold of adjudication and court costs, which would be $515 and the $150 cost of defense in this case.
Thank you. To the state.
Judge, the state's position on Ms. Wilson's case would be a withhold adjudication, 1-year probation, court costs and public defender fees, a 1-year driver's license revocation. I had written an advanced driver improvement course, but I think based on the testimony, I think I would prefer to say continued weekly AA meetings rather than imposing that driver improvement course. The state's concern as far as the need for the 1 year of probation is, so the last DUI that Ms. Wilson had was from 2020, but just last October, there was a DWLSR ticket that happened. So that was, so within less than a year, then less than 6 months, then she was back before the court with another DWLSR. At this point, because she has the HTO status, then it becomes a felony because of the history of driving license suspended and DUI for this particular defendant. So with the recency last October of the last DWLSR and then this offense date of February 18th of this year, with how soon that is from one to the other, the state feels that the 1 year of probation is appropriate in this case.
Well, Judge, we would stand by our recommendation.
Okay. To the state. So what you're seeking, a withhold, 1 year probation, 1 year driver's license suspension?
Yes, Judge.
What else? Weekly
Weekly AA meetings, that's what it sounds like. That's something that is currently going on, so we're just going to ask if that would be imposed as a condition of the court.
Okay. No other requirements other than those?
No, Judge.
This was when I was doing my homework, I read through all the letters. Very unusual because, driving while license suspended or revoked isn't something that comes before this court very often. It comes before the county courts a lot. But the way that it got to me is just very unusual, or unique, the way that it came. Read through all the letters, highlighted different things. She hit her bottom last year. A few months ago, Jen began attending our group meetings. Her motivation and determination to learn a new way to live is a breath of fresh air. I've rarely seen anyone as serious about changing their way of life. Going to any lengths to stay sober. Testimony today certainly fleshes out a lot of that. What I read, can't see emotions, can't read somebody's face from just those words. The success of AA, is just amazing when it succeeds. And it's Mr. Dial, is that right? Okay. Mr. Dial's history with that program is something that nobody can pay for. I mean, his insight and knowing whether to say somebody's trying to pull it over on the court or not, he gets a lot of credence with the court. So did the other two. Certainly, Mr. Harden with 12 Oaks and all the great work that they do. Wants to go to the meetings. I believe that. Talking to young people, I think, adds a totally different dimension to that. Somebody once said that if you're passionate about something and you suck other people in it and they follow you, I feel like you have that passion. I think that's why you want to share it with the young people. Such a rarity, Mr. Dial stated, whole life change is how he evaluates you. Based on all of that. And it was interesting when I was reading the letters, their focus on a lot of them was almost, please give her a driver's license or let her drive. I mean, that seemed to be, and I was like, wait a minute. This is broader than just the driver's license to the court. The plea agreement that you signed, shows maximum 5 years in prison. I probably have to find other things to put you in prison. Certainly not going to do that. But I mean, the downside is a heck of a lot bigger than just your driver's license, although that affects your life greatly. Because of the timing of these events, and when I did my homework, I wrote down February 18th, 23 was the subject arrest for driving while license suspended or revoked. Because in all of this, I didn't want to lose sight of what are we really talking about that brought you before the court. It's good to hear the state saying withhold of adjudication. Easy for the court to make that decision. Adjudication is withheld. You're sentenced to 1 year probation. You will need to attend weekly AA meetings. You'll need to pay the court costs, $40 per month cost of supervision, and pay the $150 public defender's fee. I'm not suspending your driver's license, okay? So you'll be able to obtain that.
Judge, if there's any suspensions or revocations from the DMV, would the court be in a position to sign an order waiving the waiting period for a business purposes only license?
Ms. Davis, you jumped up pretty quickly.
Yeah, I just want to make sure that we were clear. What Mr. McKinney is bringing up is no matter what the court does here, it doesn't change what DMV does after this case.
And that same thing, whether if I put her on probation for a year or didn't, it wasn't going to affect her driver's license.
Right.
Okay.
Correct.
Right. And yes, sir, I would. I'd be willing to sign something with the DMV stating that the court has no objection to her obtaining a hardship license or license for work. Her being able to go as far as her kids, also the AA meetings, I think that fulfills hardship.
Yes, Your Honor, and I can prepare that order and submit it to the court.
That'd be good. Thank you. Thank you for everybody coming. It means a lot to the court to see y'all, what you said. As I evaluate Ms. Wilson, she's always been very strong in her appearance that she comes. She's a tough lady. So thank you so much for being here. Okay, Mr. Shaw.
Mr. Coraggio, please.
And Judge, we're back on the record. Jay Patel and Tim Shaw on behalf of Donald Peter Coraggio, 21 CF 2651. We're making an addendum to the plea agreement as it omitted count 29. The understanding is that counts 28 and 29 are going to run concurrent with each other, but remain consecutive to counts 1 through 13 and 21 through 27. So the only change that's made is that count 29 is now concurrent to count 28. May I approach?
Yes, sir. Mr. Coraggio, if you raise your right hand, you swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Thank you, sir. You can put your hand up. So, Mr. Coraggio, does that change to the plea agreement? Does that change your decision in wishing to enter the plea?
No, Your Honor.
Because practically, what effect does it have on you?
To be honest with you, I don't.
To be honest, you don't know?
It's my understanding that it will have no effect, it being added.
I mean, as far as what you have to do or don't do, practically doesn't have any effect, right?
That's right.
Mr. Coraggio, I do accept the addendum to the plea agreement, and so counts 28 and 29 are to run concurrently with each other in consecutive to counts 1 through 13 and counts 21 through 27. Thank you, sir.
Thank you, Your Honor.
Thank you, John.
Thank you, Judge.
Thank you, sir. Yes, sir.
Judge, I have to further make these use.
Yes, sir. Thanks, Mr. King. Much. Ready? Motion to suppress?
Yes, sir.
Yes, sir.
Yes, Judge. I spoke to Mr. Stephen Spradlin, who's present to my left. Again, I went over the guideline sentence of 16.275 months DOC. My client is aware if we move forward with the motion to suppress, that offer is ultimately taken off the table. My client wishes to move forward with the motion to suppress today.
Okay. Mr. Spradlin, that's accurate. You want to go forward with this motion?
Yes, sir.
Okay. Thank you. If you want to have a seat at the council table.
Thank you.
Yes, sir. Mr. Spradlin, those chairs go up and down. If it's too low, you can raise it up or lower it down. That one seems pretty low. Mr. Kutcher, it's your motion to suppress. You kind of heard the foreshadowing of Ms. Davis. So in order to shift the burden to the state, what do you need to do?
Yes, Judge. First, do you have a copy of the motion, Judge?
I do, and I went through it. I highlighted a lot. Thank you. You know, I underlined words such as freely and voluntarily given, and highlighted different things that the court has: absence of any arrest or search warrant, search and seizure, lack of an arrest warrant in their file, you know, initiated emergency blue lights. So yes, sir, I'm up to speed.
Yes, Judge.
Judge, do you still need probation?
No, I don't think so. We don't need probation, correct? Thank you. Thank you, probation. Thanks, Rachel. Appreciate it. Yes, sir. Please.
Yes, Judge. At the four corners of my motion that's present in front of you, under Florida Rules of Criminal Procedure 3.190, I believe it's legally sufficient to move forward. Also, as you stated in that motion, I put in that there is no arrest or search warrant in the file, and I'd ask it to just notice. At this time, I believe the burden has shifted to the state, showing that there is not an arrest or search warrant in this case, and it's just to the state at this time, Judge.
Okay. Ms. Davis.
Judge, we're still at just bare bones allegations with the motion to suppress. So at this point, I don't agree that the burden has shifted to the state to prove anything at this point. Typically with a motion to suppress, there are transcripts from depositions that are attached that act as the proof to the motion as to there may have been something that was illegal about the stop. At this point, we have nothing that's been offered before the court except a lack of arrest warrant. That doesn't change whether or not there could be or couldn't be a detention. That doesn't do anything. So that would be insufficient, Judge.
Okay. So, Mr. Carter, you get the last word at your motion, but the court has no evidence. It's not a verified pleading. There aren't any affidavits, no depositions, no judicial notice of anything. So I have no evidence. I just have argument in front of me. How do I make any factual findings without any facts?
Yes, Judge. Just to be clear, the motion itself, is it sufficient, or is that an argument also? I just want to be clear on the...
A motion and a plea is, unless it's verified, is nothing more than an argument.
Yes, Judge. In some instances of doing hearings, the state objects to standing. I can today, if need be, put my client on the stand to establish that he was arrested and a search was conducted. And of course, like I say, there's no arrest or search warrant, and that would clearly shift the burden over. If the issue is a standing issue, my client is prepared to testify today.
Well, it was interesting. I think it's in this motion that you talked about standing, and I don't think I'd ever seen a standing raised in a criminal case. Certainly, your client's got standing. He's the defendant. The court can't be an advocate for either side. If you want to put on evidence, this is your time to do it.
Certainly, Judge. If I...
Judge, I want to make sure before we call the defendant to the stand that we are clear that the defendant would be subjecting himself to cross-examination, and anything he says within this courtroom would be sworn under oath and could be used against him if we go to trial. So I want to make sure that this is covered.
Yes, Judge, and like I said, once in a blue moon, I do have an objection in regards to standing in a case, and I do just put down a brief record, but if I need to prove standing, I will call my client.
It's not standing. I mean, I don't think you have to prove a right to be involved in this case is what I think about it standing. You've got that right.
Okay.
The question is, can you shift the burden to the state? Mr. Spradlin, do you understand that if you testify, whatever you testify to can be used by the state against you?
I guess I do.
Okay. You just need to communicate with your client with your attorney and make sure that you understand that if you testify, whatever you testify to, then the state has the right to ask questions, to cross-examine about those matters. Can't go outside of the direct, but anything that comes out either in that direct testimony or in cross, everything's being recorded. It can be used against you in your case. So if you need some time to talk to Mr. Koch about that, we'll give you a few minutes.
I'm good. And Judge, if standing, because I'm sorry if I misunderstood there, I thought standing was an issue with my client. So if standing is not an issue, I will not put him on the stand to show that he was arrested and searched on the day in question. I guess my argument would be under Florida Rules of Criminal Procedure 3.190, the four corners of my motion, I've established a particular evidence sought to be...
Okay, give me the rule again?
I'm sorry, Judge.
3.190G1A, is that? Tell me again.
I'm sorry, Judge. It is 3.190, and I guess we could begin with 3.190, subsection G, subsection 1, and then subsection A, alpha.
Right.
And it goes over the motion to suppress, of course. And it goes over basically what's needed to be sufficient. And one is particular evidence sought to be suppressed.
Okay, stop with the word evidence. What evidence do I have?
Yes, Judge. Per that rule, it says it has to expressly state particular evidence sought to be suppressed in the four corners of my motion.
Okay.
And then in the motion that I filed, it's page 1, evidence to be suppressed. I have any and all tangible or intangible evidence obtained.
Okay, let me stop.
Yes, Judge.
The way that I take that at this point is that the rule is saying here are the things that you need to allege in your motion. You need to allege these facts. But just because you allege them in a motion doesn't mean that they come into evidence. It just means that you've alleged them. It's an argument. So just because you file a motion doesn't mean that all those things immediately come into evidence. There could be hearsay in there. There could be all kinds of things. So again, I don't have any evidence for me to make those determinations under the rule.
Then moving past the motion, Judge, I did see, or I'm sorry, the four corners of the motion I provided.
Yes, sir.
Testimony today, I did see the sergeant outside, if I call him to testify, to lay down that evidence.
If you want to present evidence, this is your time to do.
Yes, Judge.
Who do you want to call?
I believe Sergeant Wall was...
He's not here anymore. He's not here, Judge.
Okay. Did you subpoena?
I did not, Judge.
Okay.
I saw him here. I apologize. If the court needs to hear evidence or I apologize, testimony to establish that evidence, I'd have to subpoena and request a rehearing on this, Judge.
Okay. So you're seeking a continuance of your motion to suppress?
Correct.
Okay. Ms. Davis?
Judge, I mean, it's still, let me just be really clear, so as to not waste the defendant's time. I have a case directly on point for this particular issue. If I can go ahead and hand this to Your Honor.
Thank you.
It is a first DCA case that the facts are quite identical to the facts that we're looking at in this case. So, I will also, sorry, I did go ahead and print a copy of the one of the things that that case brings up is the potential of a municipal ordinance violation, if I may approach. So I did go ahead and bring a copy of the Fort Walton Beach municipal ordinance that would be applicable to this particular case as well. Other than that, I don't necessarily have an opinion on the motion to continue at this point, but that's going to be the anticipation if we proceed forward again with the motion. And again, the state will have no offer and will not engage in any kind of plea negotiations.
If we have a hearing on the motion to strike.
Yes, Judge.
Mr. Spradlin, I do grant the motion for continuance of this motion to suppress. Certainly have a lot of thoughts that I could put on the record, but I don't think I need to at this point. I think that that's what the court needs to do. Do we want to schedule it for October 9th, October 12th?
Judge, if I have to put a second.
Yes, sir.
October 9th, October 12th. Judge, can we do the October 12th date?
Yes, sir. So October 12th at 2:30. So Mr. Spradlin, I'll see you then. There's probably a pretrial that was set for September 11th, right?
Yes.
So we'll continue that until November
Judge,
13th.
if we can keep it on that date, because at that point, if we're going to proceed forward and I need to have subs for the motion hearing, then I would like to address this so I can withdraw any plea offer at that point and I can get my subs out.
Okay, so you intend to withdraw your offer on September 11th if it's not accepted?
Yes, Judge.
Okay. So, Mr. Spradlin, I'll see you back here September 11th at 9 o'clock. So your homework is think about what the state offered you, talk to your attorney, and you decide what's in your best interest. Just know that the state intends to withdraw that 16.4 months Department of Corrections offer on September 11th if you don't accept it. Okay? And then if you don't accept it, then we'll have a hearing on October 12th on this motion.
Thank you, Judge.
Anything else on the document? Okay, we're adjourned. Thank y'all. Thank you.